The House will come to order. Members and guests, please take your seats.
Mr. Speaker,
Mr. Doorkeeper.
Mr. Speaker, the Honorable Lieutenant Governor Dan Patrick and the honorable members of the Senate are at the door of the House.
Admit the Honorable Lieutenant Governor Dan Patrick and the honorable members of the Senate. All right, the House will stand at ease awaiting the assembly of the Escort Committee and the arrival of the Chief Justice of the Supreme Court of Texas.
Mr. Speaker,
All right, the House will come to order. Members, please take your seats.
Mr. Speaker,
Mr. Doorkeeper,
the Honorable Jimmy Blacklock, Chief Justice of the Supreme Court of Texas, and his party are at the door of the House.
admit the Chief Justice and his party.
The Senate will please come to order. I hit it like you do. A quorum is present.
The House will come to order. A quorum is present. The House and Senate are meeting in joint session today pursuant to H.C.R. 5, providing for an address by the Honorable Jimmy Blaylock, Chief Justice of the Supreme Court of Texas. We are honored to have all of our guests today, including the justices of the Supreme Court of Texas, the judges of the Court of Criminal Appeals, chief justices of our Court of Appeals, our administrative regional presiding judges, and many members of law enforcement. Please help me welcome them. Additionally, I would like to take a moment to recognize our interpreters for the deaf, Tracia Beard and Aaliyah Newberry. Thank you for your services here today. I now recognize the Honorable Dan Patrick for introduction of the Chief Justice.
Members, I'm pleased to be here with all of you. Come across the rotunda to be with you today. And pleased to present to you the Honorable Jimmy Blacklock. Jimmy Blacklock. Not Blaylock, not Blackrock, Blacklock. Okay? Yeah. He is the Chief Justice. We got to get this right. The Honorable Jimmy Blacklock, Chief Justice of the Supreme Court of Texas.
Thank you. Thank you, Governor Patrick. Mr. Speaker, Blaylock is close enough. Thank you. Thank you, senators and representatives, for being here. My fellow judges, my fellow Texans, it is my great honor on this beautiful day in this beautiful and historic chamber to stand before you as the Chief Justice of the Texas Supreme Court and to report to you that the state of the judiciary in Texas is strong. There is one way, though, that we become just a little bit weaker. Our Constitution required Chief Justice Nathan Hecht to retire at the age of 75. He served 12 years as Chief Justice, 36 years on the Texas Supreme Court, 43 total years as a judge. He first became a judge just a few days after my first birthday, in 1981. He joined the Supreme Court at a difficult time in our history, the court's history. But he left the court, I'm pleased to say, far, far stronger than he found it. Nathan Hecht's legacy of service to the people of Texas is unparalleled. All of his fellow justices are so very grateful for his wise leadership and his loyal friendship over the years. But all of his fellow Texans, young and old, rich and poor, Republican and Democrat, owe Nathan Hecht a great debt of gratitude for his tireless and principled work to promote the rule of law and to make justice a greater reality for every Texan. He's here with us today. Please join me in honoring Chief Justice Nathan Lincoln Hecht. Thank you. I also want to express my gratitude to Governor Abbott for the great honor of this appointment and for giving me this unique opportunity to continue serving my fellow Texans. Thank you, Governor Abbott. But more than anything, I want to say thank you to my wife, Jessica, the love of my life, the beautiful mother of our 3 beautiful girls, a better lawyer than I am, and the greatest blessing that God has ever given me. Thank you, my love. We also need to show our gratitude to others who are with us today. I'm talking about the brave men and women of law enforcement who protect and serve law-abiding Texans across our state. You know, we judges talk a lot about what we do to defend the rule of law, and rightfully so. Sometimes judges are the rule of law's last line of defense. But the front lines in the battle for the rule of law are not courtrooms, and the warriors are not judges. No matter what laws you pass, no matter what rulings a judge makes, there will always be bad men who want to do evil, men who don't care about the law. And men like that aren't stopped by the Constitution. They aren't stopped by laws written on paper or by judges in robes. The only thing that can stop a bad man with a gun who means to do evil is a good man with a gun who means to do justice. And we have men and women like that with us today, who stand on the front lines of the fight to preserve, protect, and defend our Constitution. Would all those in law enforcement who are here with us please stand and let us honor you? Before I propose anything else, I want to ask you to do everything you can to defend the thin blue line. Support their families. Give them the tools they need to win the fight against crime and chaos and drugs. It's a fight that's often fought in the poorest and most troubled neighborhoods in our state. And the consequences of that fight fall on the poorest and most vulnerable Texans. One thing I know you're considering is changing the law and asking the people of Texas to change the Constitution so that after these officers have risked their lives to take violent criminals off the streets, that our judges are empowered and even required to keep those violent criminals in custody as they await a speedy trial. The governor has made this an emergency item, and I want to thank Senator Joan Huffman for her leadership on this vital issue of public safety. Thank you. Our gratitude to Chief Justice Hecht and to law enforcement is just part of a deeper sense of gratitude that I hope we all feel for the extraordinary blessing that it is to live in the state of Texas in the year of our Lord 2025. Our state is a beacon of liberty and hope to people all over the country and all over the world. And we're not perfect. Texas isn't perfect, but no place in this life ever will be. The legislative session encourages people to bring their grievances and their complaints to the forefront, and that's as it should be. But instead of comparing life in Texas to perfection, let's compare it to life at any other time in all of human history. When we do that, we see that this place we've been given, provides such peace and comfort and freedom and prosperity. We enjoy these rare and priceless treasures. Treasures unknown to the vast majority of people who have ever lived. how grateful then must we be to the God whose providence has put us in this time and place in Texas? And how grateful must we be to the men and women who came before us, who made possible by their toil and their blood all the blessings we enjoy in modern-day Texas. We're surrounded by their portraits in this chamber, and we can all think of our own parents and our grandparents and everything they sacrificed so that we could be here today. So for all of us in these powerful positions that God has given us, it's our job to point out the imperfections in this treasure we've been given and to propose ways to fix them. But let us proceed in doing that with humility, with gratitude, with an awareness of our own imperfections, and with the knowledge of just how precious and how rare is this treasure, this Texas that we love. I hope you'll take the rest of my remarks in that spirit. I'm going to make a few suggestions, perhaps a few complaints, but none of us should dare to complain without first acknowledging both how grateful we are for our many blessings and also acknowledging the source of those blessings. That's exactly what our founding fathers did when they wrote the Texas Constitution, which begins by humbly invoking the blessings of Almighty God. All right, so on to the suggestions. And I'll start with the top priority. If we want to attract and retain hardworking rule of law judges who are qualified to wield the extraordinary power our Constitution gives them, it is absolutely essential that we raise judicial salaries significantly this session. Texas ranks 48 out of 50 in terms of what we pay our district judges. That is not good. We're attracting people and businesses from all over the country, and a big reason is because Texas has the reputation as the kind of place where people can rely on the rule of law and where people can enjoy all of the peace and freedom and flourishing that comes with it. But if we want the rule of law to be more than just pretty words, if we want it to be a reality in the everyday lives of Texans, then the most important thing we can do is encourage smart and serious and hardworking people of high integrity who are committed to the rule of law to serve as judges and to stay as judges. But more and more it's hard to do that because of what we pay. And if these were just any government employees, those of you who know me, you know that I would be more likely to recommend a Department of Government Efficiency than a pay raise. But we're not talking about bureaucrats. We're talking about the constitutional officers of a co-equal branch of government, the officers who wield the judicial power of the state of Texas, officers prohibited by their ethical obligations from earning additional income, which distinguishes them from your positions in the legislature. And let me say thank you for the extraordinarily hard work you do for almost no pay. But judges are full-time constitutional officers who we pay significantly less than hundreds and hundreds of lawyers who work in our executive branch. Even though the judges' jobs are so much more important and the judges wield so much more power. Think about the power your local judges have over the families and businesses in your district. The power to take your money, to take your property, to take your freedom, to take your children. In terms of the economic impact on the 8th largest economy in the world, every 2 years, the amount of money that's at stake, the total amount of money at stake in Texas courtrooms, by my rough calculations, is roughly on par with the amount of money that this body will be considering in the budget later this session. And that's not to mention the enormous impact of the litigation climate on the business climate and the employment climate. Who do we want wielding all of that power and influence? Surely we want the most serious, most qualified, hardest working judges we can get. And the bottom line is this: you'll get what you pay for. Higher pay means more highly qualified people will apply. It means more highly qualified people will stay in the job for longer. That's true of any job. And if we're serious about attracting and retaining great judges, of course, salaries aren't the only piece of the puzzle, but they're an essential piece, and we can't ignore it. We have, though, pretty much ignored it for quite a while. The legislature has not raised the base pay for district judges since 2013, even as inflation has skyrocketed and as salaries for qualified lawyers have, in the private and public sector, have risen dramatically. The Judicial Compensation Commission has recommended a 30% increase in the base pay for judges this session. And that is what I am asking you to do. 30% across the board. If that sounds high, it's only because the salary hasn't gone up in 12 years. Total inflation since 2013, according to the Bureau of Labor Statistics, has been 34.5%. So I'm not even asking you to keep up with inflation. And I'm only asking that we bring Texas from number 48 to number 31 out of 50. And that may not be a particularly inspiring number, but I promise you this, if you make the commitment that I'm asking for this session, I will not be back next session asking for more money for our judges. The money is there this session, and this session is the time for the legislature to demonstrate in a dramatic and lasting way how serious we are in Texas about promoting the rule of law in our courtrooms. And I know you have a lot of people asking you for money. I appreciate that. And you might listen to this and think, those judges are just another group with their hands out. But that's not what this is. Don't think about it that way. I'm not asking you to do this for the judges. I'm certainly not asking you to do it for me. You're welcome to do whatever you want with my salary. But don't do this for the judges. Do it for your constituents who have to appear before the judges who have the power to take their money and their house and their children. Do it for the thousands of Texans whose families and whose fortunes are on the line every day in courtrooms across Texas. Do it so that you know you've done your part to help us attract and retain the kind of truly excellent people of high integrity who ought to be putting on robes and making decisions of enormous consequence for your constituents. Do it because you have a constitutional obligation to fund the judicial branch at a level that allows for fair and efficient justice to be done across our state, not for the benefit of judges, but for the benefit of the people of Texas who deserve to see that fair and efficient justice is done. I understand the concern that there are a few judges who are not pulling their weight, and frankly, they don't deserve a raise. I agree. But I'm not asking you to give this or that person a raise. That's not the way to think about this. I'm asking you to raise the stature and the appeal of these offices, which encourages more good people to apply for them. But I won't deny that there are a few judges who may not be working as hard as the job demands, and I have no tolerance for that. I'm proud of the vast majority of my fellow judges who work hard every day delivering justice for your constituents, but I have no patience for the small minority who don't. Article 5, Section 31 of the Constitution makes the Supreme Court responsible for the efficient administration of the judicial branch. And using that authority, as well as authority you've given us, we're gathering data to help us identify problem judges. We don't want to use statistical metrics like case clearance rates as blunt instruments because they don't tell the whole story. But they are very useful tools. And I believe current law provides all the tools we need to identify the problems and to deal with them. And this Supreme Court intends to do that with the help of the regional presiding judges and others. We don't need to burden all the good judges across our state with extra paperwork mandated by the legislature. We don't need to do that in order to find out where the problems are. We can find the problems, and we intend to do so. And when we find a serious problem, we can put the judge on notice that his performance is unacceptable. And if he can't turn it around, the Constitution says there are things we can do about it. Article 15, Section 8 allows the legislature, on the governor's recommendation, to remove a judge for several reasons, including willful neglect of duty and incompetence. Article 15, Section 6 allows the Supreme Court, on the petition of lawyers, to remove a district judge who, quote, negligently fails to perform his duties as judge, or who shall fail to execute in a reasonable measure the business in his court. These provisions allow us to do something about these problems. And they show us that the framers of our Constitution knew that judges have to be capable, qualified people who can manage a courtroom. The framers also knew that elections might occasionally give us people who aren't up for it. And their answer wasn't tough luck, vote them out in 4 years. No, they gave us tools to fix these problems in the very rare cases where they arise. And if we forget about these tools, or we don't use them because we think it will be too difficult, or it might make us look bad, then we're not allowing our Constitution to operate the way it was designed. Instead of holding down the salaries of 98% of judges because 2% of them aren't doing their job, we should use the power the Constitution gives us to make the 2% find another job. And we should pay all our judges a salary that is commensurate with the extraordinary responsibility that our Constitution asks them to bear. I've spoken enough about the legislature's obligation to the courts. Let me talk about the court's obligation to the legislature, which is to faithfully and consistently apply the laws that you write. Our promise to you is to apply the laws you write based strictly on their text. We will ask ourselves, what words have been enacted into law, and what do those words mean to the ordinary reader of English? That's it. We don't ask ourselves, did the legislature really mean what they said? Or wouldn't something a little different be more sensible? And we certainly don't ask, do we like this law or not? The text of the statute is the law, whether the judges like it or not, and we are bound to follow it. And the words of an enacted bill, not the aspirations of the bill's supporters, and not the instructions sent to ledge counsel, are what has passed both houses and the governor, and thereby achieved the status of law. Our obligation is to follow the text that you enact, and only that text. The only exception is if that text violates the Constitution. But again, when it comes to the Constitution, we are bound by text that we didn't choose. And we're bound not just by the constitutional text, but also by what the text meant to the people who originally ratified it. Our Constitution means the same thing yesterday, today, and tomorrow, until the people of Texas decide to change it. This is called constitutional originalism. And under this Supreme Court, it is the law in Texas. There's a competing way to read our Constitution. It's called the living Constitution. It says that the Constitution's meaning evolves over time in response to fashionable moral trends, or so-called evolving standards of decency. It says the Constitution is a living document, and the Supreme Court's job is to give it life, to decide for us when its meaning is to change. The problem, of course, is that this way of understanding the Constitution puts the judges, not the people, in charge of whether the Constitution will change. And that is not the rule of law. It sounds much more like the rule of judges. If we can all agree that judges shouldn't replace the legislature's policy choices with their own, then surely we can all agree that judges shouldn't put their own policy choices into the Constitution. But that's exactly what the idea of the living Constitution invites judges to do. And for that reason, the Texas Supreme Court has repeatedly held that originalism, not living constitutionalism, is the right way to interpret our Constitution. Hear me say this. In Texas, under this Supreme Court, the living Constitution is dead. And that fact is a big reason why I can confidently say that the state of our judiciary is strong. But another big reason is one I've already mentioned. It's the hundreds of hardworking judges all over our state who go to work every day to deliver fair and consistent justice for Texans. That includes the judges on our two newest courts, the 15th Court of Appeals and the Business Court, which you created last session. Those courts are up and running. The governor has made excellent appointments, and these judges are now doing the important work that you asked them to do. I especially want to thank Chief Justice Scott Brister of the 15th Court of Appeals for returning to the bench. Back quickly to the topic of judicial pay, he had to leave the bench many years ago to help send his daughters to the college of their dreams. But his daughters are grown, and he's back on the bench, and the state of the judiciary is stronger because of it. Consistency, predictability, fealty to the law, these are the marks of good judging. And the more consistent, predictable, and accurate our judging is, then it's not just that there will be less uncertainty and less expense associated with litigation, there will also be less litigation, fewer lawsuits. The very best litigation is the case that's never brought, the case that doesn't have to be brought because the parties know what the law is. They can predict how the courts will respond to their dispute, and so they can settle their differences out of court. It's awfully hard, though, for parties to rely on consistent and predictable rulings when they might have one judge at today's hearing and another judge at the hearing next week who may not know what happened at the first hearing. That's not a common practice in Texas, but it does exist in 2 of our counties. And it's an outlier compared to nearly all the courts across the state and across the country that I'm familiar with, where each case is assigned to a single judge whose job is to manage the case from filing to judgment. I've asked the court's advisory committee to recommend rules to eliminate this rotating docket, sometimes called the central docket. And we're open to opposing arguments, but the Constitution charges the court to make rules for the efficient and uniform administration of justice in the various courts. And it's just hard for me to see how assigning a different judge for each hearing throughout the life of a case promotes the efficient and uniform administration of justice. In an ideal world, every lawsuit would be decided based on its merits, not based on non-merits factors like the expense and trouble and uncertainty of litigation. And that's an aspirational idea, but we should work toward it. We should do everything we can to streamline and simplify litigation for both plaintiffs and defendants, and to reduce the extraordinary burden in time and money of modern litigation, particularly of discovery. The Supreme Court can amend the rules of civil procedure, and I welcome your ideas for changes along these lines. But I don't want to just complain about how other courts do business. We at the Supreme Court also need to ask whether our court, our own procedures, promote the efficient administration of justice as best they can, and we're doing that. I've asked the advisory committee to study whether the court should join nearly every other Supreme Court in the nation by waiting until we've granted a petition for review before we make the parties pay for full merits briefing. We welcome your thoughts on that as well, and on any other ideas you have for reducing the expense and burden of litigation at all levels of our courts. Chief Justice Hecht often used this speech as an opportunity to demonstrate the court's dedication to helping low-income Texans get basic legal services. That dedication remains, and the court appreciates the legislature's continued funding for these programs. The court as a whole will keep up that effort, but my focus will be on systemic reforms that make legal services more affordable for everybody, both by simplifying and streamlining the law and the rules of procedure, as I mentioned, but also by looking at how we regulate the legal profession. It's not just the poor who have trouble affording lawyers. I think it's most Texans. It's many small businesses. And basic economics tells us that as the supply of legal services goes up, the price will come down for everybody. It also tells us that government regulation of a service drives up the price. So how do we raise the supply and reduce the price of legal services? We must be open, I think, to carefully changing the way we regulate the legal profession. And one idea is to allow qualified non-lawyers to provide some basic legal services for a profit. There are plenty of other ideas, and I'm not committed to any particular version of them, nor am I interested at all in a conflict with the legislature over which branch of the government has the power to do this sort of thing. We should work together on this. If we can agree that the average Texan has been priced out of the market for many legal services, then we've all got to ask whether the way we regulate the profession is a part of that problem. And some people will oppose it. And if that opposition comes from a genuine desire to protect Texans from fraud or incompetence, then I'm all ears. But if the opposition comes from a desire to protect lawyers from economic competition, then I'm not interested. The court wants to work with the legislature on this to see if together we can make legal services more affordable for all Texans. The American Bar Association recently issued what I regret I can only describe as a political statement, aggressively taking sides in the fight going on in Washington about the scope of the president's executive power. And of course, the ABA is just a private membership organization that's entitled to speak its mind. It has a particular point of view, and its views, as far as I'm concerned, ought to carry no more weight than those of the ACLU or the Federalist Society or any other opinionated interest group. But the State Bar of Texas is a public organization, and every lawyer in Texas is compelled to join. It is therefore absolutely essential that the State Bar remain completely politically neutral in everything it does, both as a matter of substance and as a matter of the perception that its actions give to people on both sides of the aisle. The Supreme Court will accept nothing less from the State Bar, and we expect the bar to live up to that high standard. Finally, I want to return to where I started. I mentioned that the consequence of whether we win the fight against crime and drugs falls most heavily on the poorest and most vulnerable Texans. And at the court, we see this most vividly in cases where the state is attempting to terminate the legal bond between a parent and a child. In nearly all of these cases, families have been damaged or destroyed by drugs, often methamphetamine. If there's one thing you could do to help these families, it would be to help law enforcement win the war on hard drugs like meth. But innocent children are always victims in these cases. And it's tempting when we see these children in these desperate circumstances to want them removed quickly from their failing parents for their protection. But we have to remember this. Just as surely as God made those precious children, God made that family. Using the coercive power of the state to take children from their God-given parents, to destroy a family, should never be our first instinct. It should always be our very last resort. I want to thank the legislature for the work it's done in recent sessions to require DFPS to keep more families together. Senator Colcourse and Representative Dutton and others have been leaders on this, and I urge you to continue those efforts this session. And if you'll allow me, I want to make one suggestion, speaking purely for myself, which is all any of this is, of course. Look at repealing subsection O. We call it subsection O. It's chapter 161.001B10 of the Family Code. And it allows a parent's rights to be terminated forever if the parent fails to check every box on a long list of things the state wants them to do to get their child back. But the thing is, there's another provision right next to it in the code that allows termination of rights if the parent endangers the child. So the state only needs to use subsection O if it can't prove that the parent has endangered the child. But if the state can't prove that, then why on earth would we destroy that family? Termination of parental rights is the civil death penalty. When the state goes to court to take somebody's children, it's not opening up a collaborative therapy session. It's initiating adversarial litigation of the highest stakes imaginable. And we need to do more to ensure that the desperate parents in these cases have vigorous legal representation, and we need to make sure that our family code is not stacking the deck against the parents before the cases even begin. Repealing subsection O would be a good start. Representative Dutton has a bill that would do that, and many other things, and I commend his bill for your consideration. I'll close with this. The court's official motto, which is inscribed on the bench where we sit across the Capitol grounds, is in Latin. It's Sicut Patribus, sit Deus nobis. May God be with us as he was with our fathers. And surely God was with our fathers who built and sustained this beautiful state for us. And surely he has been with us as Texas has grown and prospered. Our duty now, together, across the branches of government and across the political parties, is to be good stewards of this treasure we've been given, to polish it of its imperfections, but only with great care and love, to live out the oaths that we have all taken, to preserve, protect, and defend the Constitution, and to deliver equal justice under the law for every Texan, young and old, rich and poor, Republican and Democrat. And as we work together to do all of these things, may God be with us as he was with our fathers. Thank you. God bless you. God bless Texas.
For the purpose of which this joint session was called having been completed, the Senate will now return to the Senate chamber for consideration of further business. Don't tarry. Thank you.
The purpose for which the joint session was called having been completed, the House will stand at ease pending the departure of our guests. Good job, Dan. Wonderful. Good to see you.
We'll talk later before and figure out how we're going. Perfect.